She is the staff attorney with the Reproductive Freedom Project and the lead litigator for the ACLU on the Texas SB8 case. Please welcome Julia Kaye. Julia, thank you so much for being here.
Thanks so much for having me, Jon.
So I want to start today. Attorney General Merrick Garland announced that the Department of Justice would be suing Texas over this restrictive law. Can you talk a little bit about your reaction to this announcement and what else you'd like to see the administration do?
Yeah, the Department of Justice is doing exactly the right thing here. They are coming in with bold action to try to quickly right this injustice for Texans and undo the devastation and chaos we're seeing on the ground and prevent this catastrophe from playing out in any other states that have already started to promise to follow Texas's lead. So we are really pleased about the Department of Justice's filing and looking forward to seeing how it moves forward.
So let's talk about the law and how it's written. It is strange, this way of deputizing citizens to take action in matters that has nothing to do with them in order to interfere with the reproductive freedom of people in Texas. Why did they draft it this way? And are there any other laws like this that they were drawing inspiration from?
Yeah, so their goal here was twofold. By deputizing people's neighbors and strangers to bring them into court through this bounty hunter enforcement scheme, one of the goals was to isolate abortion patients and abortion providers. But the even more devious goal here was to try to evade judicial review. So to give a little bit of context here, Texas is not the first state in recent years to try to ban abortion from the earliest stages of pregnancy. But all of those other bans were very quickly blocked in court before the laws ever took effect. And that's because, in part, they were enforced by the traditional state officials who enforce these kinds of restrictions, state health departments, prosecutors. So the courts in those cases blocked the relevant state officials from taking any enforcement action, and that was the end of the story. To try to avoid the same fate, Texas instead stripped state officials of enforcement authority and instead put it into the hands of these vigilante private individuals. And unfortunately, what we saw last week was the Supreme Court let them get away with this scheme and let the law take effect because of the nature of the enforcement structure.
So I was sort of baffled by this as a non-lawyer because my sort of layperson's understanding is that the reason that the state action was prohibited was not because of a specific issue related to state action. It was about protecting the fundamental rights of human beings, and that what matters is what impinges on the rights of the people, not who is doing the invasion of those rights. And yet it seems as though the Supreme Court, and you can tell me if you view it as purely cynical or cynical plus ideological, decided to take this as a real and serious issue worthy of their consideration. Is that right?
The Supreme Court gave very little explanation for its decision to let this 6-week abortion ban take effect. And the very short paragraph that it wrote really hid behind the technicalities of the law and said virtually nothing about the fact that this abortion ban is plainly unconstitutional under 50 years of precedent. So we will see what the Supreme Court does when the new case filed by the Department of Justice goes back before the court, which I expect will happen within just a couple of weeks. It will be a little harder then for the court to try to hide behind technicalities, and they will have to squarely confront whether they are going to turn their back on 50 years of precedent saying that states cannot ban abortion, and whether they're going to give a green light to states doing an end run around the Constitution through this bounty hunter enforcement scheme, basically deputizing private individuals to do indirectly what the state cannot do directly.
What I found sort of confusing is they are hiding behind this idea that there's novel questions and novel issues being raised. But traditionally, Isn't that exactly when the Supreme Court says, don't allow this law to go into effect while we consider it? Isn't that how it normally goes?
Yes, absolutely. If there is a novel question presented here and you're faced with a law that is going to upend a constitutional right, cause all sorts of chaos and harm on the ground, what the right thing for the court to do would be to protect the status quo while it considers any sort of novel constitutional questions. But that is not what 5 justices on the Supreme Court did last week. They shrugged their shoulders and let Texas do something that no state has been able to do since Roe v. Wade was decided in 1973.
So what happens next? We have this Texas law. We have other restrictive laws, like the one that was passed in Mississippi that I believe was a 15-week ban. What is the status of those cases, and when does the Supreme Court begin to focus on those in earnest?
Well, probably the next thing that's going to happen is that the new lawsuit, United States v. Texas, will be back before the Supreme Court. The reason I predict that that will happen quickly is because the Department of Justice is seeking a preliminary injunction. So in other words, they're seeking to immediately block any enforcement of the 6-week ban, including by these vigilante private individuals. So my best guess is that they will get that preliminary injunction because the 6-week abortion ban is so clearly unconstitutional. And then the state of Texas will likely go up to the Supreme Court within the next few weeks to ask the Supreme Court to block that preliminary injunction and allow the Texas abortion ban to take effect again. So I think we will soon see the Supreme Court again faced with the Texas case. Beyond that, there are 2 other abortion cases that the Supreme Court's going to be considering this term. The first one that I think folks don't know as much about is a case that's going to be argued in October by the ACLU that comes out of Kentucky. It's called Cameron v. EMW. And the underlying law in that case banned the most common and safest method of second trimester abortion care. We won in the courts below, and that abortion ban in Kentucky is currently blocked. But the question that the Supreme Court will be considering is whether the very anti-abortion Attorney General should have been allowed to intervene in that case at the 11th hour. So if we win on that technical question, then this Kentucky abortion ban remains blocked. But if we lose and the Attorney General is allowed to try to overturn the victory below, we may soon see an extremely harmful ban enacted in Kentucky with devastating consequences both for people in Kentucky and for neighboring states. Additionally, the Supreme Court will soon hear argument in Jackson Women's Health v. Dobbs, which is a case brought by our colleagues at the Center for Reproductive Rights on behalf of the only abortion clinic left in Mississippi. And that presents squarely the question of whether the Supreme Court should uphold or overrule Roe v. Wade. There is no way for the Supreme Court to allow Mississippi to ban abortion at 15 weeks of pregnancy without overruling the central holding of Roe v. Wade and opening the door for states to ban abortion at earlier and earlier stages.
You are fighting this multi-decade effort to restrict Roe, if not overturn Roe. We seem to be heading towards some kind of reckoning, a culmination of that fight at the Supreme Court, whether it's preserving Roe, overturning Roe, vastly restricting Roe. It's hard to understand when they have all this power, why they would choose this place to allow this test law, this ban, this overturning of Roe to stand. I just found it given the power they hold, given their ability to determine in the next few months what parts of abortion, what parts of these basic fundamental rights will be permissible in this country anymore, that this is where they chose to allow in practice, the overturning of Roe to take place. What was your reaction to it in the context of this larger fight? What does it say to you about what is about to happen at the Supreme Court?
You know, I wouldn't do this job if I weren't an idealist. And so I will be honest that I was shocked and grieving when the Supreme Court let this 6-week abortion ban take effect. I think in my heart of hearts, even though we knew that there have been changes on the court, I believed that the Supreme Court would not turn its back so unceremoniously on a half century of precedent and cause this havoc and suffering in Texas. So it was really discouraging. But as you know, the Supreme Court did not go all the way. They did not actually take this opportunity to overrule Roe v. Wade. They just ignored it. They shrugged their shoulders and said, we're not going to opine at this point on the constitutionality of the 6-week ban, but we're going to let it take effect. So I think it is a bad sign, but I don't think we really know what the court is going to do in the Mississippi case when we see that decision next June. My hope is that the tremendous public outrage that the Texas abortion ban has sparked will prompt at least one of those 5 justices to reconsider and really think about the harm not only to people who need abortion care, but also the harm to the rule of law and to the integrity of the court, and that ultimately there will not be 5 votes on the court to overrule these decades of precedent.
What can people listening do to engage and help with the fight in Texas, both legally and also just practically?
Yeah, so there is a huge amount of pain on the ground right now in Texas. The average Texan at this moment today has to travel 250 miles out of state in order to try to access this time-sensitive medical care, which means paying for transportation and hotels and childcare and losing wages in many cases for time off work. These barriers are going to be insurmountable for many patients, and these people will ultimately be forced to take on the serious pains and medical risks of pregnancy against their will. And we know that these harms are being felt most acutely by communities of color who, because of centuries of structural racism, are less likely to have the means to travel out of state. We know that because of the lack of an adequate social safety network, people with low incomes are unlikely to have money socked away for emergency cross-state travel. And we know that for young people whose parents are not supportive of their abortion decision, getting out of state is exceedingly difficult. So I urge listeners to try to mitigate some of this harm by donating to abortion funds and practical support networks and folks on the ground in Texas who have been doing this work for years to try to help people overcome barriers in order to access abortion care. Right now, that largely means helping people get out of state for care. And there's an urgent need for donations to support that effort. So you can go to the website needabortion.org to see a list of abortion funds in the state, and you can make donations there. And I think at this moment in time, that is the most urgent thing you can do for people in Texas.
It is discouraging, specifically seeing that John Roberts, Chief Justice Roberts, who joined with the 3 remaining liberals on the court to say this is clearly the wrong thing, we are doing the wrong thing, was unable to bring one of his conservative colleagues along. In a broader sense, I do think people feel a little bit powerless about how to figure out how to help at the national level when they did everything they could to elect Democrats in Congress. They did everything they could to elect Joe Biden. And yet we face this court that exists because of a conservative minority that was able to appoint it, often with electoral votes and not popular votes. What kind of pressure would you like to see people bringing to bear on their elected representatives in Congress on the Biden administration? And what would you like to see Congress do right now to kind of represent that American majority that supports the bodily autonomy of human beings in our society, unimpeded by a conservative minority imposing their views on the country?
So the good news is that there is federal legislation currently pending in Congress called the Women's Health Protection Act, or WIPA, which would create a statutory right to provide and obtain abortion care. And it would go a very long way towards preventing these kinds of egregious abortion bans, but also the junk science restrictions on abortion that we have seen in the past that can have an equally devastating effect in terms of shutting down clinics for absolutely no medical reason. So the House will soon be voting on WIPA. I would urge listeners to join the fight in support of WIPA by going to aclu.org/WHPA. And through that website, you can contact your elected officials and tell them there is an urgent need for this legislation to be passed so that we are not only relying on the constitutional right to abortion, but so that there are these statutory protections as well. And then one other thing I would add here is I think many of us are sometimes myopically focused on what's happening at the national level. You know, we're out there canvassing and phone banking when it comes to presidential elections and Senate races and so on. But these kinds of restrictions on abortion, they're being passed at the state level. These are your local state legislators, and those are the elections that it is in some ways even more important that people not sit out, that people are educating themselves about the candidates and educating their neighbors and friends, because we know that turnout is much lower in local elections, which is people don't pay as much attention. But if we are going to stop these kinds of horrific restrictions being enacted, it really starts by voting in local elections.
Last question. This is just something that frustrated me terribly today, which is on the day that you have Attorney General Merrick Garland, Attorney General, not Justice Merrick Garland, announcing a lawsuit by the United States against Texas to protect fundamental human rights, the bodily autonomy of Americans. Because of a Supreme Court ruling 5-4 that would have gone the other way had Ruth Bader Ginsburg retired a few years earlier or died a few months later, not to put too fine a point on it. You have, on that day, today, you have Justice Stephen Breyer giving yet another interview where he says his decision about retirement is very, very complicated. Do you think it's complicated?
I think I'm not going to touch that one. I'll leave it to you to give your perspective on that issue.
And that's fine. Retire, Stephen Breyer. Don't worry. No one from the ACLU said that. I said it. Watch the news, man. I'm sick of this shit. Oh, it's so complicated. It's Hamlet routine. He's got to go. Any one of these senators could die. Dianne Feinstein is 88 years old. She may be replaced by by Stephen Miller if Larry Elders wins. We got to get Stephen Breyer off the fucking bench. That's just for me. You're not even part of this anymore. I'm so sorry you were here for this.
What I will say is that although watching Attorney General Garland's press conference today was incredibly gratifying and just made me feel hope for the first time in a few days. It is really an outrage that he was prevented from getting his day in Congress and having that nomination considered. And it is truly an injustice that we are at this point, but here we are.
Julia Kaye, thank you so much.